recognized because she went through a different system.
Yes.
I think a court which is mandated to give effect or to implement human rights ought to stay with the provision of, in the best welfare of the children, the right to education which they have chosen and they have been provided for by their parents, rather than shutting away from the mainstream education system.
Okay.
Yes.
Thank you, Judge. Thank you, CJ. That's all from me.
Thank you so much, Honorable CJ. And Judge, once again, welcome.
Thank you.
Let's take a walk to Article 50, Article 6 of the Constitution. This one provides for instances where convicted persons can petition for a new trial.
Yes.
Now, in what instances can such a person file petition for a new trial?
Yeah, this is an exception to the common rule about finality of decisions in criminal cases. And the idea here is that the applicant should have exhausted, should have gone through all the steps of criminal trials, but it is given a room where there is discovery of new evidence which was not available at the time of the trial and appellate process, but which affects the outcome of the trial. It is pegged on the discovery of new evidence.
Okay, so if I get you right,
Yes.
you're saying two conditions. One, the appellate process must have been exhausted.
Yes, yes.
Or two, when there are new evidence.
Yes.
Okay. Now, when you are dealing with the second limb, that is the new and compelling evidence, what parameters do you look at as a judge to satisfy yourself that this qualifies to be new and compelling evidence?
Yes, I would have to look at a level of proof which establishes prima facie case that the outcome of this case would have been different had this evidence been availed. That it would have affected, as we say in the election terminology, it would have affected the outcome of the case. So if that threshold is reached, that on the basis of this new evidence, the outcome of the case would have been different, then the case should be reopened and determined.
Right. And what about the availability of that evidence during the trial? Is it a fact I will consider whether that evidence was available at trial?
Yes, I think in the interest of justice, so that we have balanced prosecutorial proceedings, if this evidence was available at trial and it was not brought forward, then there must be a consequence on that. Yes.
Okay, thank you so much.
Thank you.
That's all for now.
The judiciary has embraced alternative justice systems and ADR.
Yes.
Can you tell us which cases are appropriate for what kind of, give me an example of a case that's appropriate, what kind of case are appropriate for ADR and which ones are not appropriate?
In the civil process, and I have ADR as the umbrella relief of arbitration, mediation, reconciliation. Under the civil process, cases of personal nature, where in succession, for example, matrimonial, if it is possible, although the emotions in those cases hardly allow for any form of alternative dispute other than court mandated. It would be cases of personal nature that should go to ADR. But of course, in commercial disputes where we have clauses for arbitration, these ones would have to go to arbitration by virtue of the contractual agreement between the parties. You mentioned AJS, the alternative justice system, and on the criminal side of things, we have allowed also, I could also use the personal nature of claims like common assaults, issues arising from forcible detainer of property and matters like those. But we have an exclusion in matters of injury to person, particularly by way of defilements and other sexual offenses. So even when AJS has been mooted and promoted, the parties and the members of the public are always guided against use of any out-of-court settlements in sexual offenses.
What about in election disputes? Is it possible to use ADR for that?
The election disputes, in fact, have had informal ADR because we have seen cases where the petitioner comes, sometimes almost at the day of hearing, and withdraws the petition. For whatever, however it has been done, he has thought of abandoning the petition challenging the election of the candidate who was. This happens where the person who lost has found other avenues of income, and therefore is happy to wait for the next turn. But I think there was an innovation where, under the election rules, because of that kind of out-of-court settlement, the law allows another person to come over and take over the petition, so that you don't agree out there to compromise the justice of the election matter and leave the matter unaddressed. The rules allow for takeover of an election petition.
Thank you very much, Judge.
Thank you, Chair. Good morning once again, Judge.
Good morning, Commissioner.
When the Attorney General asked you a question, you said you will not promote political activism. It is argued that our Constitution is an activist and transformative document, and courts are expected to proactively interpret it in order to enforce and realize our values and social justice goals. What do you have to say about that?
What I meant by that is that, and I think I will draw examples from recent decisions of the court, that the court is not expected to fill in a gap and say, this is what Parliament should do. This is an example of the topical issue of the life sentence and term of years, where the Supreme Court has said that the Court of Appeal has no right to say that the life sentence is equal to or could well be interpreted to mean a term of years, 40 or 30 years, as has happened in some cases.
Okay, so is there a difference then between judicial activism and judicial restraint?
Judicial restraint is when, in my understanding, the court says that this matter should be dealt by Parliament, for example, because it is an organ mandated to deal with this. And we say that the doctrine of separation of powers is one for mutual respect of the respective spheres of the organs of government, so that the court will not do what ought to be done or what has been mandated to be done under the Constitution by another body.
And activism? Judicial activism?
Judicial activism is where, being the court judge, for example, being of a certain mindset, uses my proceedings and my determinations to further my beliefs. If I believed that, I want to give an example. If I believed that
okay, we can just leave it at that.
Yes.
Because I was focusing on the sample writing.
yes,
So you did submit your 5 sample writings, 3 constitutional petitions, those were decisions, and 1 RTA appeal and a conference paper. They demonstrate analytical depth and right-centered reasoning. You are able to apply the law and the fact clearly. You frame issues precisely, and you are able to reach coherent conclusions with proper use of authorities. So I commend you for that.
thank
And
you.
the
Commissioner.
conference paper you did present on electronic payments, cryptocurrency, and judicial handling of financial dispute, it shows that you are aware of the new and emerging legal issues around that particular topic. And again, I commend you for that.
Thank you.
I have taken note of the COVID-19 matter where you awarded 1.5 million
Yes.
to a petitioner after
Yes.
you held that his rights had been violated when the police were enforcing the COVID-19 regulations.
Yes.
Rights violations by the high courts, the awards are usually 1.5, and if you go to employment and labor, wrongful termination, somebody can even get 8 million.
Yes.
I know Kenyans will look at it that this is the judiciary.
Yes.
Yes, if you have anything to say about that.
I would say that constitutional damages are targeted to vindicating the violation. It may not be that we give an amount of money that rewards you for what has been done. It is to vindicate you for the breach of the rights, and to send a message to the person in case of horizontal violation, or to the state in vertical violation, that this breach is not. But I think under the labor court, they adopt a more actual. It's like on a reimbursement basis, that they give an award for the actual loss which has been incurred. I think that with this Court of Appeal, guidance may be given to courts, both us in the High Court and in the Labor Court, as to how to approach these issues of remedies by way of compensation for damages.
Okay. Even that applies to also the Environment and Land Court. If you look at the damages, you
Yes.
see the trend.
Yes.
The High Court seemed to be awarding less, but just something to note.
Yes.
Thank you for your responses.
Thank you.
Thank you, Chair.
Thank you, Chair. Good morning once again, Judge.
Good morning, Commissioner.
Yes, ability to perform is one of the qualities of a good judge.
Yes.
And because I believe you're a good judge, I want to imagine that you are well appraised of the your performance of your court, and also performance of the institution.
Yes.
Okay, so I just want to engage you briefly on the last SOJA report.
Yes.
The last SOJA. SOJA
Yes.
has reported it, yes.
Mm.
So we have certain performance indicators that
Yes.
we measure in
Yes.
our PMMU.
Yes.
One of them is case clearance rate.
Yes.
and another is backlog clearance rate.
Yes.
Could you explain to us the difference between these two?
Yes, I have interacted. In fact, I pulled out the case clearance rates for the court where I'm presently serving. And for the period between January and December 2025, we have a case clearance rate of 108%. This I understand to mean that we have in the period of the year 2025, we have dealt with all the numbers of cases filed and eaten into the backlog which we had inherited from the year 2020, which we had inherited from the year 2024. Yes, 24, because of the 8%, because of the 8 years. But I'm not clear on how to calculate the backlog clearance rate.
The backlog clearance rate, you just explained that.
Apart from court clearance rate.
The case clearance rate.
Yes.
You've explained, I think explicitly, how we arrive at the backlog clearance rate. Where I'm not very clear is the case clearance rate. So when you say you're not clear how to calculate the backlog clearance rate, I'm wondering how, because that's what you've explained in depth. What maybe we are still left in the dark is how to calculate case clearance rate.
I would hazard that the case clearance rate would be the percentage of the cases determined and finalized in the period against the cases that are filed that particular period.
Correct.
Yes.
Okay. Now, the other question, you have given us the case clearance rate of your court, Kerugoya.
Yes.
Since January, you said.
Yes.
Okay. Back to the soldier report.
Yes.
In the last review, what was the overall case clearance rate for the institution, for all the levels of court?
I beg your pardon, I have not taken that.
What about for your court, High Court? Your court was doing quite well.
I only captured the
one for your specific court.
My specific court,
okay.
Not the High Court.
The one for the Court of Appeal, which is the court you aspire to join, was 77%. Of course, we understand the challenges under which the Court of Appeal is performing. It's clear that they were not able to clear more than even what they received in the period, the period under review.
Yes.
So part of the reason we are recruiting today is to address the problem of numbers.
Yes.
And I would want to hear from you, if you're successful to join the Court of Appeal, what are you going to suggest you do so that you can improve on the case clearance rate?
Yes, 77% means that you are not, you are only slightly above 2/3 of what is coming in, and you have not even touched any backlog. The backlog remains.
Yes.
And from the reports, if the backlog is as high, then the court needs to adopt strategies for reduction of the backlog. I have, in my experience, reflected on this and thought that in addition to review of rules to allow for an expedited determination of the interlocutory applications so that the matters proceed to the appeal directly, we should also have some practice direction, and I would offer this to the Honorable Chief Justice, that in 1984, the practice then, there was practice direction of number 1 of 1984, which introduced the Friday judge matters. Friday judge matters was that on Fridays, every judge of the High Court would be given a number of minor applications to deal with, and it used to be called the Friday list. If that kind of suggestion were to be made to the Court of Appeal, and instead of having a single judge deal with the urgent applications, we have all the judges on a Friday deal with the minor applications before the court on the basis of a Friday course list, then we would be able to deal with this impediment of having to hear the applications before you go to the appeal. The rule 52B, which I understand is a major load of the court, can also be amended so that those applications are heard by a single judge. And that will just require the amendment of the rules to allow for that. Then with the judges now being available to do the Friday matters, we will now be able to go to the appeal. There is also an invention which may be looking back in history where we have come from. Under the old constitution, we had the section 84 of the constitution allowing for enforcement of fundamental rights and freedoms. And we had section 67 of the constitution allowing for a magistrate's court to refer cases to the High Court for constitutional determination. And at the time, before the rules were made, Chief Justice Apalu had said you can use the ordinary motion or summons procedure to approach the court. But in 2002, what was called the Chunga rules of 2002 had a provision for kind of a moratorium for the period between the reference under Section 67 to the determination. So that once a reference is filed in the High Court, status quo was held by virtue of those rules, Chunga rules, so that you go into the hearing of the petition. These rules were amended in 2006 by the Gishero rules. And at the time, there had been cry that, no, this automatic stay is delaying rather than helping. So the Gishero rules under Rule 23, I recall, now set the fact that now you have to apply. There is no automatic stay. You have to apply for an order for stay pending the hearing of the petition, constitutional petition. Then this is what was taken up in 2013 by Mutunga rules. Again, it was continued the practice of having to apply. So I thought that the Rules Committee, particularly here in the Court of Appeal, may think of a rule where once a valid appeal has been filed by a valid notice with leave, then there is a rule to stay the matters as happening at the time of delivery of the judgment appealed from, to allow the parties to go straight into the appeal. A form of moratorium for any action on the matter. And it is not lost that if a party is aggrieved by this automatic stay, they can come to court. But the majority of them would have had the stay granted, and we know that in about 90 days, the matter would have come to hearing when these many applications interlocutory have been removed. So I would suggest at the Court of Appeal that we consider a form of rule mandating stay, so that we remove the interlocutory appeals and we go interlocutory applications and we go into that. The other thing is...
it's okay, Judge. I'm satisfied. It's clear you've given it a lot of thought, and you've made quite a number of interesting suggestions, which I believe the Honorable CJ has had you. Thank you, and I wish you well.
Thank you.
Thank you, Honorable Chair, and welcome again, Judge.
Thank you.
Is corruption in judiciary a perception or is it real? And if it is a perception, how do we change this perception to enhance public confidence? If it is real, what steps will you take as a judge to minimize these incidences?
I think corruption in the judiciary is both perceived and actual, because you have, as a commissioner, have found various judicial officers and judges to have been involved in corruption, and you have taken appropriate action as mandated under the Constitution. But it is also a matter of perception, which is a historical injustice on the judiciary, because it is taken that the judges of Kenya judiciary are corrupt, and that all this time we have been trying to cleanse that image, even internationally, so that the perception for members of the public in Kenya and internationally need to be disabused of the notion that the Kenya judiciary is corrupt, and that is where the perception, dealing with the perception, comes in. And I think that if the judiciary took proactive steps to educate members of the public on the system of justice, on how we deal with cases, on the process of court, that when you lose a case, it need not be that the judge must have been seen in the night. The public will be able to know that you may lose a case fairly on the basis of the law and evidence. And I must commend the judiciary with the dialogue days, what we used to call open days. I know one of them is coming on the 30th of this month, and this is a forum for engagement with members of the public, where the judiciary will be able to explain the actions that we take on the evidence that we have before us, so that the members of the public will see that we are acting in line with the law and the facts that are brought up. There is also, on the aspect of actual integrity concerns, the strict enforcement of the Judicial Code of Conduct and Ethics. This is the code which was promulgated in 2020 after many trials since 2016. The Honorable Chief Justice was in the committee that was developing it, and I was privileged to sit there. I think that strict enforcement of the code would also help, because the policy ought to be, as I think, that a judge should not be dishonest or corrupt, and a corrupt person should not be a judge. So if we have persons who are judges and are corrupt, they must be removed. I don't think there is two ways about that. So the judiciary must be active in cleansing the staff, where actual cases of corruption are determined to exist. They must be dealt with firmly and with no tolerance. I think that the members of our country, of our public, are civilized enough. They can see effort being done. They can tell that something is being done about this, and they will help. They will participate as they are mandated to do under the Constitution, and we shall, on a case by case, improve the image of the judiciary as matters corruption.
Very well. Now, in your many years of experience, is there an instance you yourself faced an ethical dilemma, and what did you do? Would you kind also to share maybe with us and how you went about it?
I have not myself been approached by any person to deal with any matter other than appropriately in accordance with the law. But I have, but this was in matters of where I have acted as a presiding judge, and I have found cases have been reported to me of involvement by clerks in accepting bribes, and we have dealt with that case as LMT and escalated it to the judiciary headquarters, and action has been taken against some of those. Yeah.
Thank you, Dr. Chair.
Thank you, Honorable Chair. Judge, I have a few questions for you.
Yes.
How has the use of technology impacted the work of a judge in Kenya today, both positively and negatively?
I think the COVID situation was godsend in favor of Kenya judiciary, because we have, at the click of a button, become leading judiciary in matters of employment of ICT. Before 2020, I would say, we were lagging behind in the use of technology. And we would compare ourselves with Ethiopia, who were way ahead. But after the COVID situation came, and judges now and magistrates could do their cases from the office, I think impetus was given to develop facilities and procedures for appearance online. And now many courts, and I think the Court of Appeal is one of those courts, appear and deal with their matters virtually without formal open court sittings. What has that has done is that it has reduced costs for the litigants who have to come to court and are now able to access from their gadgets, and it has also increased the capacity by way of time for the courts to deal with many matters, because you are able to have people attend online without physical activity. It has also improved, and I must say this with the recommendation, that the law reporting aspect of the judiciary has now been developed so much that the judiciary should be thinking of employing AI, artificial intelligence, from the pool of our judicial resources at the Kenya National Law Reports. The Kenya National Law Reports, I think, would only be second to South Africa in this library. They are called law information libraries. And I think with the database that we have from the Supreme Court all the way to the magistracy and the other courts, we can have an AI, and our Dr. Kingo is an expert in this, AI research tool which gives us answers from our database, which we have developed and which has been very well developed by the Kenya Law Reports. So I am seeing an opportunity in the use of technology in many ways, both by way of hearings in court and also by the backroom activities by way of research and even judgment preparation in the matters.
Okay, any negative impact?
Yes, by way of the court proceedings. This is the one that comes to mind immediately. Court proceedings have been watered down. You have seen of situations where advocates will appear in court because online proceedings are court, when they are drinking, when they are half-dressed, and without too much care, and without sometimes ability to say who is an advocate and who is not an advocate. Those are shortcomings which I think are properly developed and implemented online appearance regulations may help. But I think the benefits outweigh these problems.
Okay, thank you. You spoke about very passionately about people who are dishonest and people who lack integrity in the judiciary, and that they should be let go.
Yes.
Now, part of the reports that we received, some of the people who described you said that you're one person who does not like dishonest people with a passion. Those people live in our midst. How do you deal with them?
Yes, I have thought about that. We can't kill all of them, but they are part of the society.
Yes.
So what we need to do is that we must make the temptation to be dishonest expensive, so that if we discover that you are dishonest, then we deal with you firmly in accordance with the law. And that will be a lesson to those others who are of like mind. And when this is done over and over, then we shall develop a mental attitude that it doesn't pay to be dishonest.
Okay.
I think the answer is in the consistent zero tolerance and consistent punishment for dishonest conduct.
Okay. Thank you, and I wish you the very best, Judge.
Thank you very much.
Yes, Judge, I'll ask you one or two questions. One is, how familiar are you with international and regional legal instruments relevant to your field?
International and legal?
Yes. International and regional
Yes.
legal instruments relevant to your field.
Yes.
And what role should developing countries play in shaping global governance norms rather than merely adapting them? Just tie the two questions.
Yes. I would want to say that in matters of constitutional practice, a judge of the High Court must be familiar with the issues of international law, international treaties, conventions that apply by virtue of Article 2 of the Constitution. And also, we also have regional instruments. We have treaties, the East African, we have the African Convention on Human Rights. I don't think that a court which deals with the constitutional matters has a way of avoiding reference. In fact, one of the rules of interpretation is that a court in comparative law, as the Honorable Attorney General had asked, must borrow and see what bearing international and regional instruments have on the work that we are doing, because those international instruments would have been entered into by the country, and therefore they are part of our constitution, and they are relevant in our day-to-day work. Question whether we should have a way of influencing rather than just taking it in as a court, the role of the court in doing that. It is my opinion that by the judicial determinations that we make, by the examinations of these instruments, regional and international, we would be able to identify gaps for improvement and for the improvement and also development where a situation arises. I am giving an example of the East African community, which is the closest home, East African Community Treaty. Although they have the East African Court of Justice, which is not a court of appeal from our courts, but which from time to time has made deliberations and decisions on our situation here. I think that in our engagement with the treaties, the court, in matters that come before them which are relevant, may be able to point out and give recommendations for consideration, yes, for improvement by our, they are called heads of state and government, who will consider what treaties may be involved. I know in some cases protocols are still to be made. Honorable Attorney General, protocol on human rights under the East African Treaty, I think that has not been done. And I think from the court here, our jurisprudence, our engagement with the outside world should be such as we are able to point out gaps and recommend action by the people who are mandated to do that.
Thank you. Thank you, CJ.
Yes, thank you very much. I think this brings us to the end of the interview.
Yes.
Very robust engagement with you, Judge.
Thank you.
So before we release you, we always give a candidate an opportunity to also engage us. If you want to ask us a question or whatever you want to tell us, the floor is yours.
I would thank the Commission for giving me the opportunity to attend an interview for the Judge of Appeal position. And importantly also, I would commend the judiciary by the procedures of this kind of recruitment, both at this level and elsewhere. It is an achievement which we must be proud of, an achievement which we must keep developing for the benefit of our own future people who come into the judiciary and also for the region. There was a time, CJ, that appointments were made outside this kind of forum, and to see that we have come to a point where judges are interviewed for suitability, I think it is a great thing. It enhances confidence of the members of the public in the judiciary of Kenya, and also internationally, to see that there is a process for appointment of judges. So I think that this is a commendable effort. And for those who are documenting this, I think they should document and share with the other judiciaries at the forums of engagement, so that we export our model of judge recruitment to the others.
Thank you. We take that commendation well.
Yes.
We are trying to build a strong institution, yes, and to promote the value of accountability, yes, because we do this on behalf of the people of Kenya.
Yes.
I wish you well on behalf of the Commission.
Thank you very much.
Keep up doing the good work. I know you have one initiative that you developed in Mombasa, the Hints of Court.
Yes, that's quite a
suggestion. It's a good practice that other courts have enumerated, yes, where the judges, the lawyers, and stakeholders engage in the spirit of trying to find out how best we can promote the rule of law and constitutionalism.
Yes.
We commend you also for that.
Thank you very much.
We will get in touch with you when we complete the process.
Thank you very much.
give our greetings to the people of Kirinyaga.
I will do that.
Thank you.
Thank you very much, Chief Justice.
My work is easy because I use ClickUp. Here's how AI saves me hours every day. It automatically prioritizes my tasks so I can focus on what's important without wasting time trying to figure out what to do next. I can ask Brain about any list to quickly get up to speed. When I need to draft documents, ClickUp Brain helps me get ideas on paper. And questions in our team channel now get automatically answered by an AI agent with expert company knowledge. ClickUp makes work easy, from personal projects to running a multi-billion-dollar company. Click the link below to create your workspace for free.
The investment we are having in education. Hawa vijana tukisha tumia pesa nyingi kuwasomesha. What happens when they come out of school, when they come out of college, when they come out of university? For a very long time, kwa hii Kenya, there was no plan. And I say so without fear of any contradiction. There was no deliberate, intentional, coherent plan on how we are going to democratize opportunity and to present opportunities for the young people of Kenya to sample so that they can participate in jobs and participate in business. Today, I stand before you as young people from the 3 counties, as I stand before the millions of young people in the Republic of Kenya. And I want to tell you this. We have 4 different pathways for you, the young people of Kenya, to get an opportunity either to work or to do business. Number 1, when we designed the housing plan was about houses, yes. It was about dignity in where Kenyans live, yes. But it was more about jobs for the millions of young people. Hii mpango yetu yote hii, watu walikuwa wananiuliza, wewe, nani alikuambia sisi tunataka manyumba? Kila mtu wako na kwake, kila mtu atajenga nyumba yake. Lakini hawakuelewa ya kwamba sio manyumba peke yake tunatafuta, ni nafasi ya ajira ya vijana. Today, as I talk to you here, young people, today, whether it is in Makueni, whether it is in Kitui, whether it is here in Machakos, there are thousands of young people, engineers, architects, quantity surveyors, electricians, plumbers, masons, carpenters, and everybody working in our housing program, whether in the housing program or in our markets program, or even right here in Machakos at the university here, we are building hostels for 2,500 students, and we have young people working there. Nyinyi mnanielewa? Today, as I talk to you, 500,000 young people who were not working 2 years ago, today they are working. Engineers, masons, architects, plumbers, carpenters, many other people in that space. We have many people working in cement factories, in steel factories, in construction industry, supporting the housing program. The housing program was designed to give young people in Kenya an opportunity to work, and they are working. Nyinyi mnanielewa? Number 2, and we designed it because Waswahili wanasema ukiona vyaelea. Yes. So jobs don't happen. Jobs are created by design And government has the responsibility to design programs that create opportunities. Number 2, we designed the program on export of labor. Why? Because Kenya has the best human capital anywhere in the world. I say so not because I am president of Kenya. I say so because if you speak to any multinational corporation anywhere in the world, if they have a choice to hire a Kenyan or to hire somebody else, they will hire a Kenyan. Because a Kenyan speaks good English, a Kenyan needs less supervision, a Kenyan ni mtu ya kujituma. So any corporation anywhere in the world, Microsoft across, they will tell you they would rather hire a Kenyan. So what did we do as government? Now that we have a resource, our human capital, we must find pathways for young people in Kenya to get opportunities to work in different parts of the world. And that is why we cleaned up the National Employment Authority. There was corruption, there was patronage, there was confusion. We removed the confusion, we removed employment entities that were stealing money from citizens. We created a green channel for making sure that if you want to go and work outside Kenya, you get a passport in 3 to 5 days. We made sure that if you don't have money to go and buy a ticket for you to go and work somewhere outside Kenya.
Cleans like bleach, with a sparkling fresh feel. Omo Bleach, tough stain removal with fresh fragrance.
3 years, 530,000 young people from Kenya are working in different parts of the world. Let me repeat. Mnanisikia? Let me repeat. For the sake of the naysayers and for the sake of the people who see nothing good in Kenya, I have some news for you. 536,000 young people from Kenya are working in different parts of the world today. Kenyans who have found a job in the last 3 years. From America to Germany, to France, to UAE, to Saudi, to Austria, and many countries in between. And we have been deliberate in making sure that we establish green channels for Kenyans to work abroad. As a result, today we are receiving an extra $1 billion from remittances from our diaspora Kenyans who are working. Because we must believe in ourselves. You know, many people don't believe in our country. So they believe that nothing good can come from Kenya. And yet they want to be leaders. I don't know why anybody would want to be a leader in a country which they don't believe in. Number 3, we have created opportunities. I said we are democratizing opportunity. And I'm saying this so that you as young people can begin to look at those opportunities. Musingoje, hakuna nafasi itakuja kukutafuta nyumbani. Vile ulijituma kwa nyota, wengine wanaweza kujituma kwa digital jobs, wengine wanaweza kujituma kwa our housing program, wengine wanaweza kujituma